So hello guys, what's up and welcome back to my YouTube channel. It's me, your girl barrister Neze, and this is Nezeville. Let us decide on this once and for all. I'm trying to make a choice as to whether to use the white background or this black background more often. Which is your preference? If you are team white, please just write white in the comment section. But if you prefer this black, please just write black. Okay, so today's video is going to be a unique one, but it will be very educative and valuable as always. In fact, I should charge my legal fees for this one. What do you think? Okay, let's come to a compromise. My fees will be for you to join us here and subscribe. So if you have learned something from me in any video, or if you learned something from this one, or if any of my videos at all have taught you something, do not fail to hit the subscribe button, ask my legal fees, turn on your bell notifications, give this video a big thumbs up, and of course drop your comments down in the comments section. So this video was born out of the many questions about marriage and the law, wills, side chicks, and all of that came up from our video on Helen Prest Ajayi. For those who haven't watched that video yet, I strongly recommend that you do. The video told the story of the late Dr. Ajayi and examined the whole legal battle over who should be recognized as his lawful wife and widow. It also touched on the separation from his wife Adenike. It touched on his relationship with former beauty queen Helen, who was socially presented as his wife for a whole 25 years. We discussed the burial disputes and the questions surrounding his estate, his properties. So watch that video for more details so you can get a better insight as to the questions that I will be answering in today's. After that video, so many of you came into the comments and even reached out privately with questions about marriage, divorce, inheritance, and what the law actually says. So in this video, I'll be answering those questions that you asked. You're welcome. Before we dive right into it, please note that this video and my responses to the questions asked are for general legal education, and they do not constitute legal advice for any individual case. The facts and applicable laws may differ from one situation to another. So if you are dealing with any situation that needs legal counseling or legal advice, please consult with a lawyer. Get a lawyer who will review your specific circumstances. All right, so let's get right into the questions. The first one here said, so how do Muslim men marry more than one wife? Great question. Now, Nigerian law operates more than one marriage system. A Muslim can lawfully marry multiple wives where his marriages are contracted under Islamic law, because Islamic marriage is potentially polygamous. Potentially meaning it's not all Muslims that subscribe to polygamy. So it is permissible to be polygamous under Islamic marriages. But being a Muslim does not give a man permission to jump between legal systems whenever it suits him. Once a man contracts a statutory marriage under the Marriage Act, which is what the late doctor contracted, he has chosen a monogamous marriage. And while that marriage lasts, while it remains legally valid, he cannot lawfully marry another, whether that second thing that he attempts doing is under statutory, under Islamic, or under customary law. Religion does not override legislation. Second question. This question, please, I really need to know, if someone weds in Assemblies of God, Nigeria, and wants to end the marriage, what way can the marriage be dissolved, since there is no marriage in registry, only traditional and church wedding? I have answered this question several times, and that's why it's important for you guys not to miss my videos, because in every video there is always something to learn. A marriage in the church and the marriage in the courts, in quotes, which we call the registry marriage, are both statutory marriages. They mean the same thing, they have the same weight, they carry the same legal consequences, they are the same. Marriage in the registry and marriage in the church under a licensed place of worship are one and the same marriage legally, and both of them can be dissolved only through the court process, only in courts. So that thing you are calling church marriage is also a statutory marriage. This person asked, how did he not have a will? Wouldn't a will have settled his wishes as to who buries him and what happens to his property at all? I thought the same thing too, honestly. A man of his age, it's not like he was a 30-something-year-old man that just had a sudden accident. A man of his age, his health status, he didn't die suddenly. He wasn't hit by a truck. He had a protracted illness, right? So a man of his age, his education, his exposure, and most especially his complicated family dynamics should have made proper legal arrangements before his death through a will. And that is why in that video that I made, I advised men, especially those who didn't or who cannot control their amunike, or those with complicated families that have already complicated their lives and the lives of others by having, multiple women, multiple children here and there. I encourage them in that video to make a will, organize their properties, document their burial wishes, clear their mess up before they go, so they do not leave their families at each other's throats trying to interpret their intentions while fighting over their body and their possessions. So yes, as we proceed with the video, we will discuss the impact a will could have had in this case. But even before we get to where I discussed about will, let us take note that a will cannot make somebody a lawful wife or erase an existing statutory marriage. If the doctor wrote in his will, I hereby renounce Adenike as my wife and hereby accept Helen as my wife, a will cannot do that. And that was the primary bone of contention in the court case, the legal status of Helen Ajayi. So a will can, yes, state how a person's wishes, how he wants his possessions to be distributed, but a will cannot erase an existing statutory marriage or create one. Okay, this person said, women need to stop centering men though. You haven't been in a man's life for so long and you are fighting to bury him. In a similar vein, this person said, I think it's incredibly sad that a man leaves a woman for 30 years, dies, and she's at his graveside still clamoring for validation with her kids. Incredibly sad. 30 years and she still cares. She hasn't moved on. She didn't forge a new path or journey. Just sad. Well, I understand your point of view totally, because it's not every woman that would sit for that or stand for that, right? But that incident, I believe, the incident at the graveside, was bigger than just fighting over a man's dead body. For Mrs. Ajayi, for Adenike, Madam Adenike, performing the burial rites was a public assertion that she remained his lawful wife, because funerals in our society are not just emotional ceremonies. They show status, they show legitimacy, and they show position. So if she just quietly stepped aside and allowed Helen to handle that tradition, her silence could have been interpreted as surrendering that legal status. So whether we agree with her or not, her action had strategic implications. She wasn't certainly fighting to reclaim his love or whatever. She was fighting to protect her legal rights and protect the interests of the 5 children that she had with the man. So I believe that was her reason. It's not really validation. The next question here says, everybody is quick to blame Helen. Do you know if the man lied that he was divorced? Who knows if he had falsified divorce documents, especially if he was estranged from his family? Well, such an excuse could fly with one who isn't learned. But the learned person knows that divorce proceedings are public documents. A legally informed person should never, ever rely on a man's word, especially in these kinds of complicated situations. A divorce decree is an official court record that can be independently verified through the courts. We have a law under Section 59 of the Nigerian Matrimonial Causes Act. Any person may apply to an issuing court for a registrar-signed certificate confirming that the divorce became absolute. So verbal assurance is not evidence of a divorce. Besides, can we really assume that Madam Helen was deceived by the late doctor and didn't know his marriage status with his wife? Can we really assume that? Your guess is as good as mine. Drop your thoughts on that. Do you think that the doctor lied to Helen about the status, or she just chose to believe what she wanted to believe? Let us get your thoughts down below. Brenda here asked, what if they were both traditionally married? Would it be the same story? So by both, she means, I believe, that if both Adenike and Helen were traditionally married only to the late doctor, will it be different? Will it be the same story? No. That could have changed a lot of things if the both women had been properly married to him under customary law. Then both could be legally recognized as wives. But in this case, the first marriage was a statutory marriage, which is legally monogamous. Your wishes cannot override the dictates of the law. So he could not validly marry another woman traditionally while that first marriage was still in force. Abiola here is asking, what about his will? My dear brother or sister, I am just as surprised as you are. Court documents reports that Dr. Ajayi died intestate. Intestate meaning he died without a valid will, which is crazy if you ask me. Elsie here is asking, at Nezeville, please explain well. I thought the law states that if couples have not had or don't have intimacy for a period of time, then the marriage is null and void. Listening to the story, it's over 35 years. Why is it still counting as marriage? Please go deeper into the law surrounding distance. Thank you, at Nezeville. Great question, Elsie. But no, a marriage does not and cannot automatically become null and void because the couple stopped having sex or because they lived apart, even if it's for 35 years. People often misunderstand the law on non-consummation. The law on non-consummation generally concerns a spouse who willfully refuses to have sexual intercourse from the beginning of the marriage, meaning the marriage has never been consummated. They've never had sex after they got married. That is the law on non-consummation. And it does not mean that an already consummated marriage expires after years without intimacy. And even in the first case of non-consummation, it is still not automatic. You didn't enter into the marriage automatically. So nothing ends the statutory marriage or any marriage at all automatically. Just as there was a process for initiating a marriage, there is a laid down process for terminating it. So you cannot just say, because this and this happened, a marriage automatically terminates. Marriage cannot be automatically terminated. There is a procedure for that. So under the Nigerian law, living apart for at least 3 years can provide strong grounds for requesting a divorce. But someone must still file it, and the court must still formally dissolve it. Distance is evidence that the marriage has broken down. It is not in itself a divorce. So although their relationship may have ended emotionally and practically decades earlier, the marriage still remained legally valid because no divorce decree was obtained. And in law, separation is not divorce, whether it lasts 3 years or 63 years. I hope you understand that. All right, let's move on to the next question. Ifoma here said, Helen, being a lawyer just like yourself, should have known better. Don't you think so? Well, I think so. Ejiofor here is asking, had it been Helen was just an ordinary side chick, but had a child to Dr. Ajayi, for Dr. Ajayi, you mean, who would have been the legitimate owner of the child? The answer is both parents. Even if Helen had only been his girlfriend, the child would still remain Helen's biological daughter and Dr. Ajayi's daughter once the paternity was acknowledged or legally established. The child belongs to both of them legally. Juliet here asks, but Neze, what happens to the daughter? Will she be given something from the estate? I need to learn. Well, yes, the daughter may still inherit, because Helen's failure to prove that she was a lawful wife does not cancel Tomisi's status as Dr. Ajayi's daughter. Even when I perused the court papers that the children of the late doctor filed in court, you will see that they gave Helen, they dashed her back her maiden name, but the child was called Tomisi Ajayi because Nigerian law forbids discrimination of children based on the circumstances of their birth. So the mother has no place because she is not a wife, but the child has some place because she is the man's child. And since Dr. Ajayi died without a will, his recognized children, including Helen's daughter Tomisi, may share the children's portion of the estate. If this case was amongst the Igbos, there was no will, and traditional law is what will guide the distribution of estate. You know how female children are ranked when it comes to the Igbos. Children get their legitimacy in Yoruba land through acknowledgement, not marriage, but children get legitimacy in Igbo land through marriage. So in Igbo land, if there was no will and estate is being distributed according to native law and custom, there might be some, although the Supreme Court has already said, oh, female children should inherit, but in reality, the reality is a bit different amongst the Igbos. So let's just stick to this case. Since this case is amongst the Yorubas, yes, Tomisi has a right to inherit from her father's estate. But let us still take notes that what I'm answering, I am speaking legally. These kinds of cases usually come with the spiritual leg, spiritual battles, which I have no jurisdiction to touch on. I am just answering legally. Okay. Let's proceed. Tinu Ade Olarinwaju here says, so what happens in families where there are 4 wives, as is in the North? Are there 2 Nigerians? I have explained this. There are not 2 Nigerians, but there are different legal systems. So choose the one that you want to be governed under by choosing the kind of marriage that you contract. Those Northerners that you are quoting with 4 wives, do you see them in the courts? Do you see them in the marriage registry undertaking statutory marriage and pledging to stay monogamous? Answer the question by yourself. Odeyemi Lekon is asking, hello Neze, hi, kudos to the good work you are doing. Can the ruling of the court, which is in favor of the first wife, override the will of the deceased if he willed his properties to the second wife, stroke concubine, stroke child, side-chick? This Ayodogu does not even know what to call Helen. He used plenty strokes. So he's asking, if the man made a will, can his will override the decision of the courts? I don't like answering divorce and polygamy questions from Ayodogus. Because I'm like, come on, God, what is your plan? What are you about? What do you intend to do? This one you're asking question. Pachapa jagi, sakwa jagi, kwacha jagi. Besides, my dear Liquor, the court rules that there is only 1 wife. So which one is first wife and second wife? Please, Araptakwalam, don't put me in trouble. There is only 1 wife in this case, and that wife is Adenike. So, having said that, not exactly can the courts overrule the will of somebody. Not generally. A man may leave his personal estate to anyone, including a partner who was not legally his wife. So a will generally, I use generally because when you now go into the Wills Act, into Wills laws, you now see plenty of loopholes and exceptions and other ways. But generally, the laws gives a man liberty to bequeath his estate to whomever he chooses and however he pleases generally. But that will can still be challenged in courts, especially over its validity. It can be challenged based on the deceased mental capacity. It can be challenged on undue influence. So as this doctor was ill now, and maybe a will comes out saying that he gave Helen all his properties, and the children are claiming that they were not informed when he was sick, that it was only Helen by his deathbed, they can challenge that will, saying that that will was made under undue influence, that the man was sick on his deathbed, and the only person who was in a position to care for him and make him live put him under undue pressure and mandated him to will his properties to her. So you go see fight for court. It can be challenged on several grounds, even on the rights of dependents. So if a man has dependents, legal dependents, and all his will just excludes them and all his properties are bequeathed to somebody else, oh boy, they will challenge it as dependents. So believe me, the battle is usually very, very long, very expensive, and very bloody. The legal wife and children can also ask the courts for what we call reasonable financial provision if the will unfairly excludes them. Oh yes. Again, he cannot will properties that were not solely his. So there is the subject of marital property, properties which were co-owned and not subject to be willed by one person. There are also some estates that cannot be willed. There are several court cases where an Igbo man willed his obi, that's his traditional home, to somebody else that was not his first son, and traditionally that's his obi is and it's traditionally supposed to be inherited by his first son. The first son challenged it in court, and the court held that that man has no right to will the obi. So wills are also very tricky. It's not as plug and play as you may think. It's not as straightforward. So you cannot just exclude your legal dependents from your estate for no reason. It will be viciously challenged, despite it is your will, in quotes. Ojuku's estate is an example of a clear expression of interest in a will that was viciously challenged. Ojuku, if you know Ojuku's case, Ojuku's will favored Bianca very heavily, but Debe Ojuku, his first son, challenged its validity and claimed entitlement to Ojuku's estate. Even after that first son died, his daughters took over and continued the case. It stretched more than a decade. So yes, a will can record a person's wishes, but it cannot guarantee or prevent a court battle. I hope you understand. Alright guys, this video has stretched way longer than I anticipated, so we're going to cut it into two because I do not want people getting, too dragged on and missing very important answers to very important questions that were asked. So I'm going to bring this video to an end here. We're going to continue in the next video, which will come almost immediately. Don't forget to drop your contributions to everything that we have discussed so far. If you are new here, you are seeing my face for the first time, don't fail to hit the subscribe button, give this video a big thumbs up, drop your thoughts down in the comment section, and stay glued because you know that there is so much more coming your way on our channel. It's me, your girl Barrister Neze, and this is Nezeville. I'll see you guys in the next one. For now, bye.